All right, good morning, everyone. I'm Mark Kleinschmidt, the President and CEO of the Anne Arundel Chamber of Commerce. I'd like you welcome to our Zoom panel. We will be hosting these occasionally to do a little deeper dive on an important issue or topic that's coming around that can affect your business. Today, we're going to be kind of talking about an HR issue. So what I'd like to do is turn it over to our chairperson, Stephen Brown, who's going to tee us up and get us started. Stephen, take it away.
All right, thank you, Mark. Well, for those of you watching, have you ever asked an employee to sign a non-compete? Or if you were an employee, have you ever been asked to sign a non-compete? Well, today we're going to address a major legal development that affects nearly 20% of Americans who answer those questions with yes. Now, my name is Stephen Brown. I'm the chair of the board of directors for the Anne Arundel County Chamber of Commerce and a partner with the regional law firm MDSW, where I focus my practice on employment law. And today, we've gathered some of the top employment lawyers in the region to give you some insight and perspective on this major legal development. But first, what is the major legal development? Well, on January 5th, 2023, the Imperial Empire, led by the Federal Trade Commission, has proposed a new rule that is aimed at ending the use of non-competes. And we all know what non-competes are. They're an agreement that says an employee can't do specific work in a specific area for a specific time after employment ends. And so this new rule would make it illegal for employers to enter into a non-compete with a worker, maintain a non-compete with a worker, or represent to a worker that the worker is subject to one. So basically saying, well, you are subject whether one may exist or not. Now, the big three things to know here, and we'll elaborate on them from this panel, are that this applies to all workers, employees, independent contractors, volunteers, interns, your clone army, whatever the case may be, they're all subject to this, not to this rule as it's proposed. Second, the rule would require employers to rescind existing employee non-competes. That's a crazy concept at the end of the day that's going to take a little noodling around to understand how that would be effective. And then finally, the non-disclosure world, the non-solicit agreements, the things that say you can't talk to a specific person or client, as of right now, those will survive this rule as long as they're not being used as de facto non-competes. So with that quick blast, I want to turn this over to our esteemed panel and jump right into some management side thoughts with Susan Shapiro and Stephen Stern. So Susan Shapiro, off to you.
Thank you, Stephen. My name is Susan Shapiro. I am an employment attorney at Counsel Baradel in Annapolis. The estimated cost, additional cost to employers of the FTC's ban on non-competes is an additional $300 billion in wages per year. That's a huge incentive for business to fight this. I know the U.S. Chamber of Commerce is already fighting it, and it's the Full Employment for Lawyers and Lobbyists Act as far as I'm concerned. So while we wait to see how this skirmish plays out, what do I recommend that businesses do? It seems to me there are a couple of different options. One is do nothing and wait and see how it plays out. But if you want to be proactive, here are some things that you might want to do. Number one, start phasing out your non-competes for your non-exempt employees. Listen, in Maryland, employers can't have a non-compete with somebody making under $15 an hour anyway. So those are going by the wayside. Might as well get that in your game plan. Number two, don't pay big bonuses to employees to sign non-competes, because if this law goes through as currently drafted, those non-competes are going to go away. Number three, beef up your other protections, non-solicitations, trade secret agreements, confidentiality provisions. Getting a trade secret agreement to stick is harder than you think, and it takes more than just having the piece of paper. And finally, improve the vibe of your business. Make sure your compensation structure is sound and competitive. People who are happy and paid well don't leave.
Thank you very much, Susan. Stephen, what do you have on this concept?
Thank you. Good morning, everyone. I'm Stephen Stern with the law firm of Kagan, Stern, Marinello, and Beard, based here in Annapolis. We also have an office in Northern Virginia. I too, one of my practice areas is employment law. And when this came out, wow, was I surprised and somewhat horrified from the business standpoint. This is an important tool. Non-competes are an important tool to helping protect trade secrets and other confidential business information. And this obviously would gut them. This is an area that's traditionally left to the states to govern. And this is maybe, I'm not making a political statement, but this is more seeming like a big overreach for the federal government to delve into this area. So a couple of things going forward. I think Susan made a lot of excellent points. I echo those sentiments. I do think it's going to be important if this rule becomes final and gets implemented. that businesses are going to really have to concentrate hard on focusing on their non-solicitation and non-disclosure agreements to help protect that information. And even then, with the way the rule is written, if this is the final rule as it's written, there's a component in there, and Steve alluded to it, about the non-disclosure component. If it's written in such a way that it can be deemed or interpreted as a non-compete, that's an area that's going to be ripe for litigation, is how broad are these non-disclosure agreements going to go, and how are the courts going to interpret them to say whether or not they are effectively acting as a non-compete. So that's one area that there's going to be a lot of uncertainty, I think, going forward. Again, if this is the final rule, there could be revisions as the comments come in. Maybe the U.S. Chamber of Commerce and other businesses will successfully defeat it or limit it. Another area that I think in the interim, until the litigation is resolved and whether this rule will become final, is the area about the notice requirements, where businesses have to affirmatively rescind these agreements, which is scary. What should a business do in this area of uncertainty while this rule is being challenged? And some could actually go ahead and rescind it if they want and just concentrate on the other areas. I could see other businesses, like Susan said, doing nothing and waiting for the litigation to play out. Hopefully, at the very least, while the litigation is playing out, there'll be a stay on the implementation of this rule. Alternatively, I could see businesses doing conditional rescission, saying the agreement is rescinded in the event that the rule becomes final. That's not recognized, that's not permitted by the rule, but I think that is maybe one middle ground to try to give businesses a little bit of wiggle room, because I don't see a lot of businesses saying, hey, we're going to rescind it. And if the rule is then found unenforceable or doesn't become final, then going ahead, so no, we rescind the rescission and everything's back in place. That's not going to fly. So that's not a good approach. I hope I'm not overstepping my time, so I'll step down now and let the panel continue.
Excellent. Well, thank you, Stephen. Thanks for those great points. We're going to switch over to the other side of the coin and talk about employee side thoughts on this new rule. So with that, I bring you Joyce Smithey to grace us with her thoughts. Oh.
Thanks, Stephen. I'm Joyce Smithey. I am on the employee side of these cases. So for purposes of today, we can call me the devil's advocate. I run a firm of 9 lawyers in Annapolis representing employees. And as I listened to Susan say the costs to employers, I heard that's the money that's going to go into the pockets of the workers. That's where those costs are going. This is going to be about employee leverage. It is shocking, and we've already heard low-wage workers. Non-competes have already been attacked a lot for low-wage workers, but you would be surprised how many have them. This is going to be a boon to leverage those workers. And again, there are many workers above $15 an hour who still cannot go out and get what they're really worth in the marketplace. And this is going to give them that leverage to do so and secure the higher pay that their talents and skills should entitle them to. Non-competes often are just a cheap retention tool. I told you I play devil advocate, but they don't cost a lot to do, for your employees that you intend to keep employed, and it causes them to have a difficult time moving around. And workers usually can't finance litigation in the same way that their employers can. So it becomes a very unfair fight to them. It stifles entrepreneurship, and we all know that's good for the economy as well. And I think that this is going to have a great effect for certain racial groups, minority groups, again, the ones that have been silenced with their leverage in the marketplace by these. And so, I view this as a wonderful thing for the employees, and it's going to put money into the pockets of the people who are working for Maryland's companies. Thanks.
Thank you, Joyce. Appreciate it very much. And so with that, we're going to go to what I'll call sort of the middle part of this, which is employers that are hiring individuals with non-competes. And I see this a lot. This is one of those things where, wait a minute, I want to bring this person on board, but what does this thing say and how is this going to drag me into it? So, it's still a business concept that these agreements can disrupt your labor pool, not just a pro-employee, pro-business concept. There's still a meaningful piece here that we want to go over. And with that, I want to bring in Melissa McGuire to address sort of what the new employer should be thinking about and viewing in this situation. So Melissa.
Thank Thank you. My name is Melissa McGuire. I have been practicing law for almost 30 years now. I'm an employment lawyer during most of that time, and I have written these agreements. I've litigated these agreements both from the employer trying to enforce their agreement side to the new employer side who's hiring someone who may have an agreement with a former employer. Or I also give advice to employers who are considering hiring someone with one of these agreements. And also employers who've hired someone who they didn't realize had one of these agreements until they get the lawyer letter from someone like me on the other side representing the former employer who has an agreement. As an employer who may be hiring employees in light of this FTC Act, I don't think it's the get out of free, you can now raid your competitor's workforce act or usurp, misappropriate their proprietary information. As Stephen mentioned, the act still permits certain other kinds of agreements like confidentiality provisions to protect proprietary and confidential information. And there's also common law protections from unfair practices. And also the confidentiality agreements can be enforceable and even non-solicitation. I'm a little concerned about this de facto piece of the rule where they say that agreements that are not necessarily non-competes, but they can act as non-competes are prohibited. Because that leaves a gray area that can still cause a lot of litigation, can still cost the employee a lot of money, can still cost both employers a lot of money if it comes to litigation. So one of my recommendations, if this act either as proposed, which I don't think is going to be the final rule as ultimately enacted, but if some variation of it is enforced, I think it's extremely important if you are hiring employees to one, ask applicants, do you have any type of agreement that you're subject to, whether it be a non-compete or any other kind of restrictive covenant, and can I see a copy of it so you can evaluate it? And there is going to be some risk in a gray area if there is a non-solicit or a non-compete component to that agreement. Even if there isn't a non-compete, if the other party, the former employer, can argue that, well, it acts as a non-compete and therefore it's void, I think that's risky. I also recommend that if you bring on an employee that is subject, is coming from a competitor, whether you have an agreement or not, that you be very careful and make it clear to the employee that they're not to use confidential information from the former employer, that you don't want any shenanigans going on. You know, if you don't want them downloading, data and bringing it to you, because that can get you into trouble regardless of whether they have a non-compete or not. I think I'm also on the agenda next to talk about next steps to implementation of this proposed rule. And in a nutshell, it's been several years since I've taken administrative law in law school, but the administrative process is such as the FTC has proposed this rule, and it's open for public comment. And you can go right on the FTC site for the rule and submit comments. They have specific questions that they wanted answered. Some of them, one of them is whether franchisees should be covered by the rule. As of right now, franchisees aren't covered by the rule, although independent contractors are, and volunteers and all those other folks that Steve mentioned at the beginning. So they do have a list of specific information that they're requesting, but also if there's information that you want them to consider, or public wants them to consider, they are open and they should be considering that feedback. So after they take that feedback and consider it, then they will issue a final rule, which probably will not be in the same format as it is right now. Hopefully it will be what I call watered down, at least some and then it'll be implemented or published. For the final rule will be published. And then at that point, I suspect, depending on what version is published, I think regardless of what version is published, watered down or not, it's going to be subject to legal challenge, including possibly a stay. From some court may issue a stay. And I'll turn it over to Steve to see if he has some additional comments on the implementation and next steps of the rule.
Thank you. Really quick on, I know I talked a little bit about some of the implementation before. I'm really interested to see how it plays out with this rescission requirement while it's in flux. I really hope the courts at least stay the implementation of the rule for that time period, because otherwise it's just a trap for businesses and it leads to a lot of uncertainty, not just with businesses. Being fair to Joyce side, on the employee side, people won't really know what to do and how to comport themselves. So that's one thing. I do think it's going to be an interesting development too about how, again, assuming there's some implementation of this rule and the provision in it that talks about the implementation of non-disclosure agreements. I said before, I think there'll be an area ripe with litigation. I will tell you, when I review non-disclosure agreements that are written by other people, I do think they're really broad, but are they so broad to be effectively non-compete agreements? I don't necessarily think that's often the case, even with the broadest ones that I see. So I'm not really sure how that's going to play out. Although I do think it's kind of an attack on what's called the inevitable disclosure doctrine, which under case law recognizes in some jurisdictions that an employee who worked at company X and goes to work for company Y cannot effectively separate or distinguish, compartmentalize confidential information they learned in one place and use it in the next job. Therefore, you can effectively implement a non-compete agreement on that employee, sort of like the executive vice president of marketing for Pepsi going to become the executive vice president of marketing for Coke. You can't do one job without thinking about what you learned at the other job. But for those businesses here in Maryland does not recognize the inevitable disclosure doctrine, so probably not that big of a deal for Maryland businesses. But if you are conducting businesses in other states and have employees in other states, there are other jurisdictions that recognize that. So this is going to be a fascinating clash, I think, between federal reach and state law. Our role of federalism in this country, and how the Supreme Court, if it eventually gets there, which I expect it will rule on this. So from a lawyer standpoint, it'll be fascinating, but at the same time, from a practical standpoint, it makes me a little bit nervous. I don't want to overstep my time. I know we had very brief steps to implementation, so I'll step down now and pass it on.
All right. Well, thank you guys so much for that. The implementation part. I mean, it's just a crazy time. It's such a flux because more often than not, my experience has been everybody just sort of wants to do the right thing. There's still, every occasionally there's some missteps here and there that maybe people didn't think through, whatever the case may be. But both employers want to protect themselves, new employers want to do the right thing, and the employee just wants to go where they're going. So, litigation happens, sure does. We want to make sure that everybody knows what's right and what's wrong. But this sort of clouding moment is going to be a tough time for pretty much all involved until it gets straightened out. But with that, I want to come in with a lightning round of bold predictions of where this goes. So I'm going to start with Joyce. Joyce, what do you got? Where does this rule go?
Thanks, Stephen. You asked for bold predictions.
Yeah.
Bold. This is going to pass, in my opinion, and I don't think it's going to be watered down. This has been in development and talk since 2020, I believe. Even vocal opponents to this rule are conceding often when they speak about it. They think it's going to pass. So I think it's coming, but I agree with everyone else on this panel. There is going to be a lot of litigation afterwards challenging that rulemaking authority of the agency for doing this. And there is going to be a period that is going to be uncertain for everyone, employees and business owners.
Thank you very much. And then Susan Shapiro, bold prediction.
I think over the next decade, we're going to see more and more chipping away at non-compete agreements and their ability to be upheld in court. Now, whether that will be through this FTC rule or through some new statute or through state legislation, I'm not quite sure, but I think we're going to see less and less protection in this regard.
All right. And Stephen Stern, bold prediction.
Wow, bold prediction. I actually think I may disagree. I think I'm going to disagree with Joyce on this one. I think with this conservative court, there's a pretty decent chance it does not get implemented, but consistent with, if that were to be the case, I think Susan is right about the future of non-competes. They will be available under state law But all along, I mean, the way the law is really already interpreted, it's up to businesses to really write these in a narrow way. And there's a lot of misinformation out there about how people think they're not enforceable. That's not true. I just think there's so many poor ones that are written that are overbroad. It leads to a lot of bad outcomes in litigation. So if businesses really invest the time, effort, and resources to do it right on the front end, there'll be more implementation or enforcement and less of these crazy outcomes. But that's my take on it.
All right, excellent. And Melissa, what do you have? Bold prediction.
Well, coming on the end of this, I don't know if it's as bold as it was, if it had been at the start, but I do think that either it's going to be watered down or possibly defeated on by the Supreme Court judicially. But I do, in follow up to that, I do think a lot of state legislatures might adopt this framework on a state by state basis, particularly those in the blue states. So whether it passes through this FTC process or not, I think we're going to be looking at a lot of these restrictions in various states after this.
All right. Well, I'm going to hold you all to those bold predictions because it is recorded. So we will play that game later on. We'll see who had the best one most closely. I will do Price is Right rule, so close but not going over. Real on a little bit to Steve's point and Melissa's point, and well, frankly, the ones opposing this, there was a dissent published by one of the FTC members, and he said, with all due respect to the majority, I am dubious that 3 unelected technocrats, ooh, big words, have somehow hit upon the right way to think about non-competes, and that all the preceding legal minds to examine this issue have gotten it wrong. I thought that was a nice little jumble of words to throw out against his peers on that board. But I think that's my bold prediction, is that I think that if this gets to the Supreme Court, they'll tackle the 3 people versus, maybe a major question doctrine, or, something that should be reserved to Congress. So to all of you that said that it probably gets adopted on a state by state basis on a legislator in a blue state, I would feel strongly that that's a realistic possibility. And in Maryland, we are blue all the way up now. So keep in play. Well, with that, everybody, I am super excited and thrilled that we were able to put this together. For those watching, everybody's bios and links to their firms will be in the comments. Feel free to reach out to anybody, but reach out to an employment attorney. It is very important to reach out to folks with specific experience in this field, because it is a landmine when it comes to litigation if you get it wrong, both for employees and employers. And like I said throughout, I think everybody's just trying to do it right. So reach out to anybody on this panel except for Mark, and we will make sure that you get where you need to be and you get the right advice in working all this out. So with that, I think I'll bring this to a conclusion.
All right, well, great. I want to thank the panel. You have done a great job kind of outlining a very topical issue that's happening in real time. And I think our members and businesses need to invest their funds up front to make sure that they're properly documented as the law changes. So again, thank you so much. And anyone interested, you will have the information so you can contact any of these fabulous attorneys to get your info and get your HR issues squared away. So thanks, and stay tuned as this issue continues to percolate.